Good morning. We would like to welcome everyone to the May session of the Supreme Court. In light of the current public health situation, we are conducting this session remotely. The court felt it best to proceed in this manner rather than canceling or postponing the session, because it is vital the courts continue to function, even in the most difficult of times. Traditionally, our court does not impose time limits on counsel, but due to the unique circumstances, we have developed a special protocol, which has been forwarded to all counsel who will be presenting our. As counsel has been advised, they will each have a maximum of 20 minutes. We've reserved a brief period at the beginning, aspirationally at the end, for opening and closing remarks. And although we would ask that counsel keep an eye on their watches, I will alert them at the 2-minute mark and ask them to promptly conclude. Justices who may have questions will pose them in a preset order in order that counsel might focus their attention on the justice asking the question. Finally, as is custom, I will briefly state the case in order to frame the issue before the court. And Mr. Minner, with that, would you please call the first case?
First argument is in re Passarelli Family Trust, appeal of Margaret G. Passarelli, arguing on behalf of Ms. Appellant, John McKenna. Arguing on behalf of appellee Joseph Passarelli is Mark R. Ashton. Arguing on behalf of appellee guardian ad litem is Douglas W. Olshan.
Good morning, Mr. McKenna. In this case, the appellant seeks to terminate an irrevocable trust that she created with Aplt during the marriage. The particular legal question involved is whether the appellee acted fraudulently when he did not disclose the nature of certain marital property that was being transferred to the trust.
Thank you, Mr. Chief Justice Saylor and Associate Justice. If it pleases the court, my name is John McKenna. I'm counsel for Margaret Passarelli, the appellant. We're here today to discuss the issue of interpretation of Section 7736 of the Tax Code that states a trust is voidable to the extent its creation was induced by fraud. Further, the question is, what is that for said fraud? It should be noted from the outset that this statute does not differentiate between a revocable and an irrevocable trust because the legislature clearly did not differentiate it. The Superior Court, in essence, overruled its own holding in Glover and introduced a heightened standard of scrutiny based on the fact that the trust was designated as an irrevocable trust. We're here to examine whether the level of scrutiny was appropriate or necessary, and how do we apply globally, and particularly in this case. Here we have a case where a husband is living a double life. Unknown to a pregnant wife, husband had purchased 2 homes in Florida, one in which he provided for his girlfriend and his family to live rent-free. Throughout this case, it's been our contention, and the trial court agreed, that had Mrs. Passarelli known these facts, she would not have signed the trust agreement, giving her husband total control of the marital assets. In fact, when this case was brought before the family court, the appellee husband used this trust as a shield against equitable distribution. Mrs. Passarelli did not have an opportunity to review any of the documents prior to the May 21st, 2015 meeting, of which this is a 5-year anniversary today. The documents were drafted only from input from the husband. Husband hired the attorney. Husband alone compiled the inventory of assets. Most importantly, the court found that Mrs. Passarelli would sign any document that the husband put in front of her. In fact, the husband so testified. With reference to the level of scrutiny, we believe that the Falls estate and Glover estate provide a perfect analysis of the situation where a trust is executed while the wife had no knowledge of the concealed or mistaken fact, and she would not have signed the trust agreement had she known the truth. husband made a misrepresentation in the form of a non-disclosure of a material fact to induce wife to sign a trust agreement with the intent to shield him from equitable distribution and give him full control of the assets. We ask that in the alternative, the restatement third of property, wills, and donative transfers could be adopted in that donative transfers, which are procured by fraud, if the father knowingly or recklessly made a misrepresentation to the donor of a material fact that was intended to and did lead the donor to make the transfer that the donor would not otherwise have made.
Thank you, Mr. McKenna. We'll begin the questioning with Justice Baer.
Thank you, Chief Justice. One of the imports of this case to us, perhaps less than you, is what's the appropriate test for fraud? So the Superior Court looked at Paul, which was our case, and said, well, that's an undue influence case, and therefore their decision in Glover was erroneous because it adopted a fraud standard premised upon an undue influence case. I'm curious of your view, if you thought about what the test should be before we try to apply the test. Do you think Glover is correct, or did the Superior Court do fine in positing the test here, and their error, in your view, was in applying it?
I think that it's twofold. It's first that they made a differentiation between an irrevocable trust and a revocable one, where the statute doesn't. So they based their need for a heightened level of scrutiny based on the fact that it was irrevocable. Since the legislature didn't choose to make a difference between the two, we thought that was misplaced. However, we do believe that Glover is and was the law of the land with reference to situations where disclosures should be made, and if they're not made, that it induces the donor or the co-trustee to sign the document. If they had known of that fact, they would not have signed the document. And the court so found that after hearing all of the evidence.
Let me interrupt you only because time is short given this format, with apologies to try to get to it. Is the material misrepresentation here, and I appreciate that no one should make light of these facts, but is the material misrepresentation here that he had his girlfriend living down there and didn't tell her, or that he purchased 2 homes in Florida and didn't tell her, or both?
I think it's a combination of the two, Your Honor, and I do believe that this isn't somebody who was, sneaking around and going to hotel rooms. He actually took marital assets, purchased this house through a company that he owned solely to hide the fact, because it disclosed the company and its value. We think that's irrelevant.
So may I ask you, if he had disclosed that he bought these 2 homes, he said, honey, I think Florida is an up-and-coming community. I have an opportunity to pick up 2 houses inexpensively. And she said, whatever you think, you take care of the money. Still a material misrepresentation because he neglected to say that he has a girlfriend living in one of them?
I think it's the fact that he used marital assets to purchase it, even though it was through the company that's still his company, which also was a marital asset, later became a trust asset. So we believe that the fraud comes in when it's also the motivation for why he does it. Why did he make it an irrevocable trust when trust itself had no tax advantage whatsoever, because he maintained full control? If you look at the trust, he gets full control of all the assets and conveyed principal at any time. There's no, oh, I had to go to the court. There's total discretion in his hands. And he
all right, I think.
Thank you, Mr. McKenna. We'll move to Justice Todd.
Thank you, Your Honor.
Thank you, Chief Justice. Mr. McKenna, I have no difficulty finding misconduct, misrepresentation in the marriage in connection with this purchase of the home in Florida where the mistress and her family lived. My problem with your argument is I'm not convinced that that equates to fraudulent inducement to enter into the trust. Wife acknowledged, I believe, that husband did not misrepresent to her the corpus of the trust, and she willingly deferred to husband's financial judgment. And it's not unreasonable to conclude that she would have signed on to the trust, entered into the trust regardless. So I'd like you to delineate for me your distinction between his misconduct and bad behavior and fraudulent inducement to enter the trust.
Thank you. I do think that again, that we believe the motive, the intention is controlling here. His intention was to make sure that when she finally did find out, because it's inevitable she was going to find out, that he would have used this trust to defeat equitable distribution. In fact, he did. And then the second point is that he also maintains control of these assets. So he doesn't tell her about this because he knew, and was a clever man, that he'll make $14 million by being stupid. Clever person, he knew darn well that when it came time to get divorced, he had control of all the assets and the court had no ability to deal with it. So the motive is extremely important here. And I think that the fact that he didn't disclose these assets is almost not relevant to the motive. The motive is he's having an affair, he's having a separate life, and he uses these assets and puts them in a corporation so she doesn't find out about what's in there. If you look at the trust asset list, it just says, company, here's what it's worth. It doesn't say that there's this houses. So he's leading the separate.
Excuse me, he didn't represent the amount. He didn't represent the total, the corpus.
He did.
He did represent the amounts. He said that it's worth $4.2 million. He didn't say what's in the
Exactly.
Yes. That's right. If I misspoke, I apologize. But in the case here, because he had a preordained, he's the only one that talked to the lawyer. Wife had exactly 1 hour to deal with not only the trust, but a will, the power of attorney, and the healthcare power of attorney.
Okay, I understand your argument. Thank you.
Thank you, Mr. Justice Donahue.
Good morning, counsel.
Good morning.
As I've read the transcripts in your briefs, what occurred to me is, and I'm assuming you did this intentionally, you're conflating or obscuring what your client's actual problem is with this transaction. And as I read it, your client's complaint has nothing to do with the raise of the trust. It has to do with the fact that her husband didn't disclose that he was involved in an extramarital affair. And so my question to you is, why was the approach taken to attack the non-disclosure of the property in one of the LLPs, as opposed to asking for potentially a reformation of the trust so that the trustee was someone other than the husband? I mean, I understand the argument. I would never have given him control over all of these assets had I known he was involved in an extramarital affair. But that doesn't get you a invalidation of the trust. That would get you potentially a route you didn't take for whatever reason, a request for a replacement of the trustee.
Well, actually, the case started out in family court. Judge Bortner of the family court sent it over to the orphans court because of the trust was being used as a shield against equitable distribution. And
but can I just interrupt there? Because, I mean, I understand what your argument is, but there was no divorce pending when this trust was established. So, I mean, I understand what your issue is, but to me,
I'm sorry, I can't hear.
Well, we lost temporarily Justice Donahue, so we'll move to Justice Doherty.
Counsel, if we were to hold, can you see me? I lost you all for a second.
I can see you, Judge.
Okay. If we were to consider that husband did make a misrepresentation, considering that the combined value of the properties were approximately $470,000 compared to a $14 million trust, how would you define that misrepresentation to being material to the value?
Material to the value, not. I wouldn't. And that, as I said, I think the value of these properties is not the issue or important. What I think is important is the preordained, pre-planned vehicle used by the husband in order to shield his companies and everything so that wife would never have any chance. And we're just trying to level the playing field here, and he has made sure that is not going to happen based on not disclosing it to her. So it's not the issue of what's the value, and gee, it's only 5% of the trust. The issue is what was, this was a vehicle, and the danger, the social danger of this whole scheme of his is that it invites people to do likewise and to say, hey, let's throw everything in a trust. And if the motive is to, hey, we're going to get a divorce, and what is a better thing to do than to throw everything into a trust and make it, call it irrevocable, even though it doesn't have any tax advantage whatsoever. Just so the court can, cannot be able to attack the trust in family court.
Thank you, Justice Doherty. Any follow-up before we move to Justice Wecht?
No, thanks, sir.
Justice Wecht.
Thank you, Chief Justice. Good morning, Counsel.
Good morning.
Counsel, since, if not since Blackstone, at least since the ALI was set up back in the 20s, we've all known what the 6 elements of fraud are. And I found no fact-finding by the Orphans Court here on the 6 elements. A couple of them are missing, including scienter, and you yourself just said there's no materiality. The case is about voiding a trust and not about placing moral blame. Can we agree on that?
Yeah, it's about voiding a trust.
Okay, so here's the question. You've got an orphans court number opened. Why not go over to family court and in domestic relations, litigate your economic claims in divorce, including the marital misconduct issue? And if the judge needs to get at the trust, you've got an orphans court number open, and there you go. I don't understand why the tail's wagging the dog here, and why you're trying to change the law on our longstanding requirements for fraud, all that so you can find a way to use the infidelity as a way to strike the trust. Can you explain that to me?
Sure. First of all, I do not believe that we're using the infidelity. I want to be heard on the motive issue. I know I keep hitting it because I think it's really important here, is that this was pre-planned. This isn't something that just happened out of the blue. In terms of fraud, at the time, Glover was the lay of the land. Now, with reference to the restatement, we talked about the restatement in my opening, and that provides a guidepost for fraud cases. We also believe that even though, because number one, the family court referred it over to the orphans court, it reached a point where the husband was saying that you can't, let's not talk about these assets because it's an irrevocable trust. And the judge said, well, that's cute. Basically, he uses that language because that means that anytime anybody just wants to defeat equitable distribution, just create this trust. So he referred it over to the orphans court. We followed, they instructed us to, and suggested we file a petition, which we did.
Okay. Anything else, Justice Wick?
No, thank you, counsel. Thank you, Chief Justice.
Justice Mundy, do you have a question?
No questions.
Thank you. Well, I think we have, oh, good, Justice Donahue is back on, but I think our time is
I'm by
pretty
telephone.
Oh, by telephone.
Yes.
Okay, well, Justice Donahue, we lost you for a minute. We're at the 2-minute mark, and you were kind of interrupted. So, did you have a question?
Okay. That's okay, Chief. I'll pass for now. I don't want to break the pace.
Thank you. Well, thank you, Mr. McKenna. We certainly understand and apprehend your argument. And so we will now turn to counsel for the appellee. I believe that, Brian, we have two counsel present, and they would both like to, they would like to divide their time. Is that in essence? So Mr. Ashton and Mr. Olson, we'll start, I guess, with Mr. Ashton, and you can begin your argument, and then when we come to Mr. Olson, you know, the admonition is always we would like to avoid redundancy, even though there are two appellees, since I believe that in essence it's but a fairly straight case. Mr. Ashton.
Good morning, Mr. Chief Justice and fellow members of the court. What I would like to do is appropriate my 3 minutes. I'm happy to yield to any questions the court has to Mr. Olson in terms of issues that are before you as justices that you'd like to pose to either one of us. My name is Mark Ashton, and I represent Joe Passarelli, the fellow who seems to have created this controversy 5 years ago, because he thought it was provident at that time to put all his own assets and all joint assets in a trust for himself, his wife, and his kids. I note that on that day 5 years ago, he contributed $7 million of assets titled in his name alone, and another $6.5 million in assets that he and Mrs. Passarelli held jointly to a new enterprise called the Passarelli Family Irrevocable Trust. In doing so, he also took on all of the duties that are inherent in the role of trustee. In effect, he contracted to become a fiduciary. I make this otherwise self-evident point because I believe the standard for fraud in the context of an inter vivos trust should be a contract standard of fraud as concluded by the Superior Court 14 months ago. As I understand it, we are here today to try to reconcile perceived differences between the Superior Court ruling of 14 months ago, a 1962 Supreme Court ruling called Paul's Estate, and a subsequent Superior Court case called Estate of Glover. My goal today is to try to be helpful to you in making those policy decisions. In preparation, I've read the litany of cases again and again. The estate cases are hard ones because the range of fraudulent activities is quite broad, and in both Paul's Estate and the Glover Estate, the court is stuck to speculate what the decedent would have done had the decedent known all the facts when preparing their wills. In all of these cases, including Paul, Rebidas versus Marasco, there are strong hints of infirmity and undue influence. We do not have that here. We have two college-educated adults in the prime of their lives trying to secure their wealth for their future. Among the assets husband put into the trust for himself and his wife are two $250,000 houses. Those rental properties compose roughly 3% of the entire estate. The gravamen of the fraud claim in this case is that because the co-grantor of the trust professes that she did not know about these assets, the entire trust must fail. The Superior Court termed that claim patently absurd for two reasons, I believe. First, there is no duty under trust law to parse every asset going into a trust. Second, the two offending dwellings contributed $470,000 to the greater good of the Passarelli family, including Mrs. Passarelli. Third, and perhaps least important, the non-disclosure is immaterial. The two houses, as Mr. McKenna concedes, are 3% of the trust race, and they weren't taken from the trust or hidden by stealth. They were put into the trust for the benefit of the family. So while I understand the rather what I would describe as weak two-part test applied in the Glover case, to wit, I didn't know the facts, and had the decedent known all the facts, the will she had written would not have been written as it had. I don't believe it has merit in the context of an inter vivos trust setting. Here, all of the parties, the grantors, the trustee, the beneficiaries are alive. And a low threshold, which is I didn't know and I would have done otherwise, is a situation which can be used as a weapon to accomplish other purposes, which is what I think has been done here. The Glover test invites an unhappy party to any fact and claim that to claim any fact is sufficient to say I didn't know it and the trust should be disbanded. The Passarelli parents here signed a trust to preserve wealth. If a party wants that contract rescinded, let her prove the same elements of misrepresentation. Materiality, justifiable reliance, and damage as in any other contract. It's indicated in the Supreme Court decision.
Mr. Ashton, sorry to interrupt you, but you can take your whole 10 minutes. But if you do that, then obviously you've elected to forego any questioning by the court. So it's your choice, and you might better help your cause if you know you're available to respond to any questions the justices might have. But that's your choice. Do you want to just keep going?
No, sir, Your Honor. I'm happy to answer questions.
Okay. Well, we'll start with Justice Baer, and you know, by the time we're through any questions, we'll have moved to the other counsel for appellee, Justice Baer.
Thank you, Chief. And Mr. Ashton, you'll forgive me if I perhaps interrupt you, because I have a few questions that I want to ask in a very limited time. Your opposing counsel suggests that we should pull the lens back on this transaction and look at it as a totality. And that, and obviously, I've not read the record, I've not read the transcripts, and somebody will do that, or we'll all do that. But that this was an elaborate scheme, that he hid these homes in Japan, that he had only one lawyer and did an irrevocable trust. And his design, which he then carried out, was to get to equitable distribution and try to disinherit her the $14 million that they had jointly attributed. Why is that wrong? Why wasn't the trust just one component of a scheme to walk away from the marriage with everything?
Well, Your Honor, let's put it this way. If we look, first of all, Mrs. Passarelli indicated on the record in her testimony that she wanted to preserve these assets, that she was aware of the consequence of divorce. These were questions that she posed to the lawyer the day that she signed it. Moreover, JPEN is actually a company that was used, that Mr. Passarelli and his former partner owned, that was used to hold real estate long before the business was sold, for the business that he and his partner owned, for the substantial amount of money that is today in trust.
Let me interrupt you for 1 second. Let me interrupt you 1 second again, because time is short. Let's talk about JPEN a little bit more. Does it own anything beside these two homes?
Oh, yes. It owns 5 other residential properties, if I have it correct, Your Honor, and it owned probably $750,000 of surety bonds. And was the wife aware of all that? Well, Your Honor, let's put it this way. I don't know if she knew exactly what was in JPEN. JPEN was disclosed, as Mr. McKenna indicated, as having a value of $4.2 million, and that value is uncontested. It was uncontested in the hearing, which tells me she knew something about it.
Thank you. Justice Scott.
I have no questions, Chief Justice.
Thank you. Justice Donahue.
Counsel, as to the, I'd like to ask you your view on the specificity with which the assets of this trust needed to be disclosed. As I understand it, JPEN is a real estate limited partnership. Is that correct?
Well, I'm going to say too, its primary assets are real estate, and if I recall correctly, was created for that purpose.
Okay, so the actual asset in the trust was JPEN, correct?
Well, it's JPEN, understand, it's JPEN represented $4.2 million of the roughly $7 million that Mr. Passarelli put into the trust. Okay.
I understand that, but my question is really specific to the asset that is at issue here. Your opposing counsel takes the position that the assets are all of the assets held by the limited partnership. As I understand your position and the reasoning of the Superior Court, the asset is in fact the limited partnership. Do you agree with that contention?
Let me be clear. The trust indenture, which is in the record, the trust indenture identifies the asset conveyed as assets of the LLP JPEN properties. That $200,000 or $470,000 of that $4.2 million consists of these two offending homes. The balance of it consists of other residential real estate up and down the East Coast.
I understand that, counsel. I mean, but the question as I see it is it sufficient to disclose the asset, i.e. JPEN, and its valuation in total? I believe Judge Lazarus used the example of, let's say one of the assets of the trust was a corporation. Would it be necessary to disclose all of the property held by the corporation, i.e. buildings, desks, file cabinets, etc., or is it sufficient to disclose the existence of the corporation as part of the raise of the trust and to put a value on it? And I'm assuming your position aligns with that of the Superior Court.
It does. And what we're suggesting here is that, again, this can be used as a device to, quote, break apart trusts for other reasons. For example, suppose Mr. Passarelli's investment account held stock in Mallinckrodt or some of the other companies that are opioid manufacturers. I can understand where someone might be offended by that or any other form of asset, whether it was Krugerrands at that time. Anybody can be offended by an asset, but the fact of the matter is that the trust law does not require us to disclose each and every asset being contributed. Think of a car dealership. I mean, there's a huge number of assets.
I understand that. Let me just interrupt so I could get in one more question. Your opposing counsel appears now, and somewhat in his brief, but more so now, taking a position that this case has something to do with a perpetration of a fraud in general, as opposed to the manner in which I understand this case was developed, which is this was a challenge to a non-disclosure of assets within this one limited partnership. Are we not confined in addressing this case to the facts and theories upon which it was developed, i.e. an attack on the non-disclosure of one of the assets in the trust?
Well, I see this as a little bit differently in how it was presented. It was presented at first as there was a need to disclose the relationship, the personal relationship, in order for the trust to be valid. The trial court decided that it was going to invalidate the trust based upon the non-disclosure of the two properties. Now, and at various points during this argument, the wife has taken different positions on that, and basically either advanced it as saying, well, the non-disclosure of the asset was enough, and the other is the non-disclosure of the relationship. I think Mr. Olson's brief does a fine job of elucidating the fact that how are we to define what is a relationship and what it means, and where does that line get drawn? I think that's a very difficult task for any court to try to do.
Thank you, Mr. McCaffrey. Thank you, Mr. Ashton. We'll turn in the remaining 10 minutes to Mr. Olson.
Thank you, Chief Justice. If it please the court, again, my name's Douglas Olson. I was appointed as guardian ad litem on behalf of the two Passarelli family children. And if I may utilize my time for the limited issue in attempting to address what Justice Todd and Justice Donahue briefly characterized as the misconduct claim. Generally, when dealing with financial disclosures, when dealing with disclosures generally, either in the
domestic relations context or in the estate context, we're dealing with financials. We're not dealing with misconduct or extramarital affairs. There's no case law, as I could find it, dealing with the need to make those types of disclosures. And when I was preparing for this argument, I had an opportunity to watch Monday's stream, and I saw Justice Baer posit a number of hypotheticals, which got me and Mr. Ashton thinking, well, what would this do to settle domestic relations law if, upon advancing Mr. McKenna's argument, there was a requirement to begin making these types of disclosures? And effectively, we run the risk of invalidating or calling into question the validity of any number of prenuptial agreements. Because as practitioners, the proclivities of our clients are generally not our concern. It's what are your financials, what's your income, and is the disclosure made either sufficient enough, or was there a full waiver as found in the Bennett case quoted by Mr. McKenna's client? The bigger problem is if you make a generalized finding that this type of misconduct is a necessary element of disclosure, does that call into question whether or not premarital misconduct must be disclosed? Otherwise, you call into question the validity of a marriage under 3305 dealing with annulments. There's no case law that I could find in the Commonwealth dealing with that issue. There are limited references to premarital unchastity, as I could find it in the ALR. But generally, again, the fraud referenced for annulments doesn't delve into what Ms. Passarelli would ask this court to adopt now.
Thank you, Mr. Olson. I'd like to, before you conclude, though, ask if some of the remaining justices might have a question of you, starting with Justice Doherty.
No questions.
Justice Wecht.
Thank you. For Mr. Ashton, a couple questions, Chief Justice. Mr. Ashton, would you agree that there's no reason why we should go astray from these 6 longstanding elements for fraud?
Yeah, absolutely. As I said, I view this as a contract case. When I say that, I think this trust is a contract. It has duties that run in both directions, and therefore should be decided as a contract case, not an estate case.
The other question I had for you, sir, is the wife brought the divorce claim, and I understand on her petition for special relief, the family, the domestic relations court froze a substantial amount of the trust corpus. Isn't that right?
Yeah, and he tried to freeze half of it. Effectively, he controlled all of it. He froze all of it.
Yeah. So then wife brings her petition for termination of the trust in the orphans court. My question is, so you've got these 2 actions there. Why can't they be consolidated? And then she can litigate the misconduct claims in the alimony issue to the extent that's there. And if for some reason there aren't enough assets at the end of this game to adjudicate the economic claims in divorce, the trust corpus hasn't gone anywhere. And if the 6 elements for fraud are made out, voidability is available. Why isn't that the way that this should be handled?
Well, I tend to, I don't entirely agree with your analysis, but I tend to agree with the premise of it, which is these people made a conscious decision to put assets in trust. So there is a trust, and the trust is subject to orphans court's exclusive jurisdiction. There are retirement assets and other things that they own personally, and there are also alimony claims, all of which are perfectly adjudicable in the family court division. So I see this as a situation where there are 2 sets of claims, both of which have validity and both of which can proceed without conflating the 2.
Thank you. Justice Mundy, do you have a question before we conclude?
No questions. Thank you.
Mr. Olson, do you have a word you would like to say by way of summary?
The only last thing I would add is that parties to divorce litigation tend to utilize other vehicles to quote unquote defeat equitable distribution. It's not always frowned upon. We find it quite often in either prenuptial or antenuptial agreements. The question is always whether a fair disclosure was made. And arguably, as Mr. Ashton indicated earlier, such a disclosure was made in this case, even though it wasn't necessarily required. I think that the last comment I'll make is that the scrivener testified that there was a conscious decision on his part to identify the assets in Schedule A of the trust as they were identified, because the corporate interest was what was transferred. There was other documentation that was admitted at the time of trial that showed the earlier spreadsheets that contained each identifiable assets that the schedule was culled from. So obviously that calls into question whether or not there was this intent on the part of Mr. Passarelli to create this scheme of fraud when the information was both delivered to the scrivener and by the scrivener's own admission culled from in order to make the schedule of disclosure.
Thank you. Thanks to all counsels. With that, we'll conclude the argument and reconvene for the next argument at 10:15.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
This argument is in the matter of JF versus the Department of Human Services. Arguing on behalf of appellant is Attorney Rebecca Taylor. Arguing on behalf of appellee is Christopher this matter is in John P. Sivick versus the State Ethics Commission. Arguing on behalf of appellant is Edmund Healy. Arguing on behalf of appellee is Jeffrey Frankenberg.
Good morning. While a member of a township's board of supervisors, appellant secured employment for his son and thereafter verified his son's timesheets. The State Ethics Commission determined that appellant violated the conflicts of interest provision of the Ethics Act and ordered him to pay restitution. Appellant is challenging these determinations. Mr. Healy.
Good morning, Mr. Chief Justice and members of the court. I am Edmund Healy, counsel for the appellant John P. Sivick. May it please the court. Both issues in this case have a common theme. What kinds of factual evidence must the Commonwealth provide to meet the requirements of the Ethics Act? I'd like to address the less complicated issue of restitution first. It was stipulated in the record, and both the Commission and Commonwealth Court found that Mr. Sivick's son was a maintenance worker on the road crew under Mr. Sivick's immediate supervision as Director of Public Works, and that Mr. Sivick was an elected member of the Board of Supervisors and, in fact, the chairman of the Board of Supervisors. In its adjudication, the Commission ordered Mr. Sivick to pay restitution in the amount of $30,000 for the private pecuniary benefit received by his son as a laborer. Commonwealth Court upheld this order. This is not authorized by the Act. As always, the best way to determine the intent and purpose of any statute is to focus on the words actually employed by the General Assembly. Power given to the Commission to order restitution appears in only one place in the entire Act. Section 1107.13, sentence number 3 is that location. Very clear. It's very clear, quote, any order resulting from a finding that a public official or public employee has obtained a financial gain in violation of this chapter may require the restitution plus interest of that gain to the appropriate governmental body, close quote. It's never been contended that his son was a public official or a public employee as those terms are defined by 1102 of the Act. Instead, both the Commission and the Commonwealth Court identified only John P. Sivick, the respondent, as a public official and a public employee. This is set forth in conclusion of law number 1 of the Commission's determination. But by focusing on the actual words in the statute, the legislature only permits restitution where a, quote, public official or public employee has obtained financial gain, quote. Therefore, by legislative determination, restitution is not available under any broader circumstances, such as any time compensation is paid or received in violation of the Act. Frankly, the phrase to obtain inherently restricts the list of recipients to only the public official or public employee, or at a minimum requires the public official and public employee to have come into contact with the compensation. The record here doesn't support that, and therefore the interpretation of the statute is founded. The Commission and the Court erred by adding language to 1107.13 to allow restitution for any, quote, financial gain benefiting the public official or public employee or a member of his immediate family, close quote. That's actually from the Commonwealth Court decision at pages 24 and 25 of the memorandum opinion. That legislative option wasn't pursued, it wasn't enacted by the General Assembly, and it is not within the purview of either the Commission or the Commonwealth Court to insert that additional language into the statute.
Thank you, Mr. Healy. We'll begin the questioning with Justice Todd.
Thank you, Chief Justice. Good morning, counsel.
Good morning.
There are cases out there where the public official has obtained a job for someone, obtained a benefit for someone who may or may not be a family member, and then the public official receives a kickback or receives some sort of financial gain from that employment. That is clearly not the case here. Is that correct?
That's correct.
So there are other penalties under the Ethics Act for the violation act other than restitution. Is that correct?
Yes, ma'am.
So I guess what I'm getting at is under the plain meaning of the act, under the plain reading of the text, and under the facts of this case giving rise to the misconduct or the violation of the act, there is nothing that restitution could address because the public official himself did not receive any financial gain. Is that your argument?
That is my position, yes, Madam Justice.
All right, I have nothing further. Thank you.
Thank you. Justice Donahue?
Counsel, if we can look at the second issue, I'm assuming you plan on arguing the second issue. You just didn't do an opening on it.
That's correct.
Okay. As I understand the facts of this case, the review of the timesheets or personnel records by the appellant of an employee who happened to be his son was really essentially done in the ordinary course of business, and there's no evidence that the son was treated any differently than any other employee who was in that subclass of individuals whose personnel records the appellant reviewed. Am I correct?
Yes, Justice. That's exactly correct.
And as I understand your argument, absent evidence of some disparate treatment of, in this case, the son, the statute clearly encompasses and affirms the propriety of the conduct in which your client was involved in this case.
I believe the absence of evidence to support a conclusion that he treated his son differently means that there cannot be a finding that he violated the conflict of interest requirements. The threshold requirement into the conflict of interest requires it to be something more than being treated within a class. It requires to be treated differently from being a member of the class. And this class it consists of all full-time employees under Mr. Sivick's immediate supervision. And there's just no evidence comparing the hours worked by or paid for to Mr. Sivick's son versus anybody else on the road crew under Mr. Sivick's supervision. I believe that there has to be some proof of that. There is no per se rule here. I think the statute requires something beyond that threshold. That's very clear from the definition itself, where it says this term does not include, et cetera, et cetera. That means above that is when you get into the zone of whether you have a conflict of interest that can be asserted on a probably a per se basis or something to that effect. There's just no proof that elevates it above that minimum threshold.
Okay, thank you, counsel.
Thank you. Justice Doherty?
I don't have any questions for counsel.
Thank you. Justice Webb?
Counsel, thank you, Chief Justice. Counsel, do you agree that there is some ambiguity in the statute, or do you not agree?
Ambiguity in the statute? I think the statute is fine. It's hard to use this breaking up. I don't have any other feedback sources here. I believe the statute uses words that are easy to follow. And if the words are given their normal accorded meaning, for example, that it has to, there has to be something that says he was not treated to the same degree as a class or other group, which includes a public official or members of his immediate family to the same degree. I don't think you get to that conflict problem. There has to be something that says it's different with respect to a member of the same class.
Thank you.
And I'm sorry, one more, if I may, Mr. Justice. There is a lack of cases that actually get into that distinction of what is the meaning of being in the same class to the same degree affected by the action. There are very few cases that I've found that deal with that, at least in Pennsylvania.
Thank you. Justice Mundy?
I have no questions.
Thank you. Justice Bear?
Let me take you back to the first argument that you made at length. And you looked at 1107.13 and you pointed out the language public employees obtain financial gain. But you didn't go further. It says, in violation of this chapter, which is chapter 11, and that includes 1103, which says that it's a violation of the Ethics Act to engage in a conflict of interest. And then 1102 that defines conflict of interest and says to provide private pecuniary gain to a member of your immediate family. So I'm a little lost. I understand that analysis requires a couple steps, but we're capable of taking a couple steps. Why doesn't that indicate that indeed your client violated the chapter by engaging in a conflict of interest, allowing private pecuniary gain to his son?
Mr. Justice, that is essentially the position taken by the Commission itself, of course. But the fact of the matter is, under the restitution provision of 1107.13, you have to both violate the Act itself and you have to fall within the classification of being a public official or public employee who has obtained a financial gain in violation of the Act. In other words, yes.
Let me interrupt you. I understand that, and I think you would be correct. You may be correct, no, but you would be correct, but for the fact that it seems as if this Act redefines or clarifies, as Justice White said to you, potentially ambiguous by saying if there is a financial gain to your son, that is a financial gain to you under the legislative construction of the statute. And that's what I'm trying to explore.
Okay, well,
so I'm looking at 1102 more than 1107.
Well, 1107 is the actual language that sets forth the restitutional power. I mean, there's no additional words or language in there. This has to be considered the result of, probably legislative compromise and certainly discussion. But when they settle on the words that where a public official or a public employee has obtained a financial gain, that's the only time that they're allowing restitution to be ordered. Nothing else.
Thank you, Counsel. Thank you, Chief.
Thank you. Thank you, Mr. Hilly. If you had a brief moment or two of summation, we'll turn to the appellee.
I believe the court actually understands the arguments. I believe the questions identify the areas of concern, and I think they're fully fleshed out in my brief. I'll be willing to submit on the argument already submitted.
Thank you. Mr. Frankenberger.
Thank you, Chief Justice, and may it please the court. My name is Jeff Frankenberger, and I'm Assistant Counsel for the Investigative Division of the Pennsylvania State Ethics Commission. The restitution ordered in this case was proper because Section 1107.13 is not ambiguous. Appellant obtained a financial benefit for his son in violation of the Ethics Act. I think Justice Baer hit the nail on the head when he said that the important language of this section of the law is that any order resulting from a finding that a public official or public employee has obtained a financial gain in violation of this chapter may require restitution. The Commission has been holding this way since restitution was allowable by the courts after one of the amendments to the Ethics Act. And there is a doctrine of agency deference that I think should be applied to this case, just like in the Rendell versus SEC decision that this court handled over a decade ago. In that case, the court had to determine what business meant under the Ethics Act, whether profits, for-profit businesses or non-profit businesses could be included in the definition of business. And this court went into an analysis and found that non-profit businesses are also included in that definition. They use the doctrine of agency deference. They also use some statutory construction. And I think the same thing can be used here. The court looked at the possible consequences in what was going to happen if they ruled that nonprofits were not part of business. And so in this case, if you rule that a public official can funnel money, whether it's like in this case through employment, or in other cases like giving grants to their businesses, you're opening the floodgates for millions of dollars to be able to go to public officials, family members, with no recourse for them having to pay it back. And what the court also did in Rendell, and what you should do in this case, is you should look at the purpose of the Ethics Act. and that is that public office and public employment is a public trust. And any violation of that public trust is going to diminish the effectiveness of government in this Commonwealth. And if you have public officials who are able to give their sons jobs, and the way that this public official gave his son a job, he sent his son to a township-paid flagger course 3 months before the son even applied for a job at the township. The son filled out an application, didn't list his father, and then he was hired 7 days after his application, 3 months later, without any formal recorded vote by the township. These are all bad acts that constitute uses of offices that resulted in the financial gain. And so, leading on to the second point, his son was treated differently. His father concocted a scheme where he lobbied individual township supervisors, and the scheme is laid out by the Commonwealth Court and the Commission in its entirety. And you can't forget about that in this case. Because
Frankenberger, I think we allowed you time for an opening, but we're going to move to questioning and start with Justice Todd.
Mr. Frankenberger, if we agree there was a violation of the Ethics Act, but do not agree that restitution is in order, are there other penalties to Mr. Sivick?
Well, the penalties that are available under the Ethics Act that the Commission can do, they can issue a public order, which they have done. They can refer the case for prosecution by the District Attorney's Office or the Attorney General's Office. But that's really it. And then the appellant and his son would get away with money that they earned illegally.
Well, you use the phrase funnel monies to his son, that he used this scheme to funnel money through. There's no evidence on this record, from what I have read, that there was any funneling involved. And that's my problem with the restitution remedy. The son is not, there's no indication that he's giving kickbacks to his father or that his father got some financial gain from it. So I'm hard pressed under the language of the Act to see where restitution comes in.
Thank you, Justice. Actually, there is something in the record in which the appellant was lobbying one of the other supervisors for them to hire his son because he knew that he couldn't vote on it. He had to abstain. And he said that his son really needed the job because his son was going through a tough time. And unfortunately, not all the people in Pennsylvania who are unemployed and who are going through tough times have a family member who's a public official who can use their position illegally to get them a job to help them through those tough times.
And I understand that, sir. Your argument goes to a violation of the Ethics Act, not to the remedy of restitution, respectfully.
I disagree with that, Your Honor, but it's noted. Thank you.
Thank you, counsel.
Thank you, Justice Donahue.
No questions, Chief. Thank you.
Thank you, Justice Doherty.
Counsel, the concern that I have is the salary was what, $126,000? What was?
That was the total amount that he received, and the net was about 87, correct?
Right, so that's over the 3-year period. And you keep referring to his illegal receipt. He was in fact gainfully employed and receiving a check, correct?
Correct, Your Honor.
And he was receiving a similar check such as every other employee, but in a different capacity, who works for the county.
Correct, but the other employees were not hired via use of office by their father.
So really, you're alleging the offense is nepotism as opposed to a conflict, or are you saying they're one and the same?
In this instance, they're one and the same, but a conflict of interest isn't always nepotism, and nepotism isn't always a conflict of interest because there are ways that his son could have been employed by the township that would not have been a conflict of interest. If he would have, if the father would have not been involved in lobbying the other supervisors, not been involved in removing the nepotism policy that prohibited the other supervisors from hiring his son. Those actions are what constitute the uses of office at the beginning of this that make it illegal under the Ethics Act.
And where do you find the justification or the basis for a $30,000 restitution based on 3-year aggregate of $126,000?
Thank you, Your Honor. In the order, first of all, in the statute 110713, it says that the commission may order restitution, so it is discretionary. And unfortunately, in their order, the commission did not go into detail about how they came about that $30,000 figure. So anything that I could say to that would be speculation, as I was the prosecutor in the case. I was not the fact finder, and the commission did not go into that. So I cannot tell you how that $30,000 figure was determined.
Thank you.
Thank you. I don't think there's a dispute over the actual figure, though, is it? That's not in the case.
No, Your Honor.
But it's the fact of restitution itself. Justice Wecht.
Thank you, Chief Justice. Can you hear me, counsel?
Yes, Your Honor, I can.
Okay, thanks. Because my video is down for a moment on this end. Counsel, you have talked at length about bad acts, etc. But the issue here isn't the moral blameworthiness of Mr. Sivick Sr.'s actions. The issue for us is the statute, which we have to construe rather than reconstruct. Would you agree?
I agree.
All right. In that regard, why is it so absurd that the General Assembly to consider that it's possible that in the different language the General Assembly used in sections 1102 and 1107, the General Assembly might have considered that a 5-year prison sentence and a $10,000 fine might be sufficient deterrence for the employee, and that the restitution reaching beyond to family members would not be necessary then?
I think that they could have easily left out the language in section 110713 stating in violation of this chapter. And if that language wasn't there, then Mr. Healy's argument, I'm not sure that I could really have a counter argument to that.
Well, following up on that, you keep talking about the in violation of this chapter. It can be in violation of the cosmos, but there still has to be financial gain. Isn't that correct?
Correct.
So how can you get us to make the leap from financial gain to Sivick the son to jump from that to financial gain to Sivick the father?
I think that the answer to that is the usage of the words in the statute, which is the word obtain. It's not received. If the word was received, then you and Mr. Healy would I think be correct that you can't make that leap. But because the word is obtain, I can obtain something for someone else. Every time I order Grubhub, the delivery man obtains me a meal from whatever restaurant he goes to.
Right, and in that scenario, presumably evidence would have been put on that the food went from the middle person to the end consumer, right?
Well, correct. I can also
You don't have that. You don't have that in this record, do you? You don't have evidence in your record here of transactions conveying these monies from Sivick the son to Sivick the father, do you?
I do not.
All right. Well, that's a big missing piece, isn't it?
I respectfully disagree, Your Honor. If I can change my Grubhub scenario a second, I can also order Grubhub and have it delivered somewhere else. And therefore, the Grubhub delivery person is obtaining a sandwich for someone else.
Thank you.
Thank you. Justice Mundy.
I have no questions. Thank you.
Thank you. Justice Bear, and then we'll conclude.
Mr. Frankenberger, I'd like to look at the second issue, which is the question of the fact that the father reviewed the payroll records. And of course, there's the exception there for the whatever it is, part, subpart, where you're just part of a body. So if you're the chief financial officer of Apple, and it's 100,000 or whatever it is employees, and you look casually through the computer printout and sign your name to verify that you've seen it, would there be a violation under that section?
No, Your Honor, but that is factually very different from the situation that is here before the court.
All right. And in the Cranes case, you're the county controller of Berks County, and your husband's an employee. Was it correctly decided that there was no violation because, again, he's part of the subpart of the statute?
I disagree that that case. Oh, pardon me, Your Honor. I disagree that I think that case was incorrectly decided, number one. But if it was correctly decided, it is entirely distinguishable from the case at hand.
Okay, go ahead and distinguish it.
Sure. So in the Cranes case, her husband was working for that governmental entity long before she became a public official of it. And in this case, the appellant was a public official and used his office to hire his son in violation of the Ethics Act, and then treated his son differently because, let me back up a second. He did not view and sign off on the hours worked by these employees altogether. He reviewed each employee's timesheet individually.
Does the record say that?
Yes, and that is what the Commonwealth Court and the Commission both held.
Well, you've already told, and I'm about done. You told me Cranes is wrongly decided. If in Cranes, and I don't know, Berks County has 100 employees, let's just assume that. And if the controller had looked at each record individually and signed it, that's the fact that distinguishes from the Apple scenario?
Yes.
Okay, thank you so much.
Thank you, Your Honor.
Thank you. Thanks to both counsel. Mr. Frankenberger, you're allowed, under our protocol, a moment or two to conclude if you'd like, and if not, we'll move to the next case.
Thank you, Your Honor. I'll just take a moment. The purpose of the Ethics Act is to ensure that the Commonwealth's public officials and public employees are not using their positions for the financial benefit of themselves, immediate family members, or businesses that they associate with. If you find in favor of the appellant in this case, you will damage that public trust in their public officials at a time that's crucial for the continued success of this Commonwealth. So we ask you to affirm the Commonwealth Court's decision. Thank you.
Thank you. Thanks to both counsel. Conclude the argument and move to the next argument at 11 a.m.
Thank you.
This argument is in JF versus the Department of Human Services. Arguing on behalf of appellant is Attorney Rebecca Taylor. Arguing on behalf of appellee is Christopher P. Light.
Good morning. Per the Child Protective Services law, the Department of Human Services maintains a statewide database which includes reports of child abuse. In this tracking system, founded reports are distinguished from other categories of reports such as indicated or unfounded ones. Report is founded where there has been either a judicial adjudication or an acceptance into an accelerated rehabilitative disposition program, and the adjudication or reason for acceptance involves the same factual circumstances involved in the allegation of child abuse. A report was made that Aplt committed child abuse, and she was subsequently accepted into an accelerated rehabilitative disposition program. The issue presented concerns whether Aplt was entitled to a hearing to determine if her acceptance into that program supported the labeling of the report as unfounded. And with that, I would appreciate if you could introduce yourself, Taylor, and begin your argument.
Good morning, and may it please the court. My name is Rebecca Taylor, and I represent the Department of Human Services. An administrative hearing is not required on a founded child abuse report when the report is founded based on acceptance into an accelerated rehabilitative disposition program, and the perpetrator admits that the reason for entry into ARD based on the same factual circumstances as the underlying child abuse. This is supported by the plain language of the Child Protective Services Law and evidenced by the intent of the legislature in its amendment of the definition of founded report. The CPS law, since an amendment in 2013, allows for a report to be founded based solely into entry into ARD as long as the facts and circumstances of the underlying abuse report are the same. Commonwealth Court reversed the decision of the Department's Bureau of Hearings and Appeals and required a hearing in this case because they were not adjudicated facts found during ARD entry, which is not generally part of the accelerated rehabilitative disposition process. In its opinion, Commonwealth Court emphasizes the first sentence of subparagraph 1 of the definition of founded report. There has been a judicial adjudication based on a finding that a child who is the subject of the report has been abused, and the adjudication involves the same factual circumstances involved in the allegation of child abuse. But the ARD provision is found in subparagraph 2, and the judicial adjudication requirement of the prior paragraph doesn't apply. By adding ARD to the definition of founded report, the legislature established that entry into ARD should be grounds for a founded child abuse report, and to require adjudicated facts before a child abuse report can be given a founded status circumvents the legislative intent of that 2013 amendment. Much like one of the purposes of ARD is to allow a first-time offender to undergo some sanctions, but ultimately get a clean slate, a report founded on ARD does not have to be permanent, and once ARD is successfully completed and the criminal record is expunged, the perpetrator can seek removal of that founded status. Commonwealth Court, in its decision below, reviewed 2 of its prior decisions where it determined that a perpetrator of child abuse was entitled to an administrative hearing in order to determine if the underlying judicial adjudication could support the founded report. However, both of those cases were decided before the CPSL was amended to include entry into ARD and are materially distinguishable from this case.
Thank you. We'll begin the questioning by calling on Justice Donahue.
Thank you, Chief. Counsel, the factual predicate in this case that you rely on and the, pardon me, the dissenting judge in the Commonwealth Court is that the appellee here admits that the factual circumstances surrounding the entrance into the ARD program are the same as the factual circumstances giving rise to the child abuse charge. If there was not that agreement and there was a dispute as to the similarity of the factual circumstances, in that situation, what is your view as to whether or not a hearing would be permitted?
In that circumstance, BHA should have held a hearing or should hold a hearing for the limited purpose of determining whether or not those facts and circumstances are the same.
And how would they do that?
I'm sorry?
And how would they accomplish that?
That's something that has actually been done with our administrative tribunal for years. And what the administrative law judge accepts as evidence of those facts and circumstances changes. One of the cases cited in the Commonwealth Court below that I say is materially distinguishable is actually a good example of this in this case. It's the RF case. And in that case, the child abuse report was founded based on sexual abuse, but the perpetrator of the child abuse report in the criminal case ultimately pled to endangering the welfare of a child. You can't look at those two things and say that endangering the welfare of a child is necessarily sexual abuse. And so therefore there was a hearing to see if those charges, if those circumstances matched up. Here, the reason requested for a hearing is because there was no judicial determination concerning severity of injury, that the defendant may be innocent of the allegation but choose to enter ARD, which isn't part of the statute, and that she should be granted a hearing to explain her version of the incident and reasons for entering ARD, which gets a little closer, but is still not disputing the facts.
Okay, thank you.
Thank you. Justice Doherty.
Well, counsel, pursuant to 6341A2, an individual is entitled to a hearing for an indicated report. The facts of this case show that there was 2 indicated reports. It wasn't until her acceptance into ARD that your office amended and made it a founded report. Why is she not guaranteed a hearing under the 90-day window of which she applied when she was quote unquote indicated as opposed to founded?
Well, when the report was indicated, she did in fact receive appeal rights and appeal that decision. But before that hearing could be held, the status was changed to founded. Therefore, the indicated status sort of goes away and the right to appeal afforded under A2 is gone.
When you say it goes away, can you direct me to the statute that says that? Or is that just practice so that you could avoid providing an indicated report that's being appealed a right to a fair hearing?
That is practice, but it's not to avoid the right to a fair hearing. It's that the founded status exists because there is generally a common pleas court. There is another court action that generally holds a higher burden of proof than our substantial evidence requirement on an indicated report. And as I mentioned before, that founded status based on ARD doesn't have to be permanent. Based on section 6341C.1, when a case that has been founded, if the perpetrator can show the department that the underlying court action that founded the case has been reversed or vacated, then the founded status is removed. That case would then be put back into the indicated status, and all appeal rights would exist.
Okay.
Thank you. Justice Wecht.
Thank you, Chief Justice. Counsel, with respect to 6303A2, quote, the same factual circumstances, unquote. My question for you is, how are we to make the jump, the leap, from verbiage in a CYF report or a criminal complaint to a determination as a matter of law that the factual circumstances are the same? We can't just sort of rough guesstimate that, can we? Wouldn't the appropriate thing to do for you to get a court reporter over to the ARD hearing, get some sort of stipulation or at least some verbiage on the record from the ARD hearing so that somebody some adjudicator could say, yep, those are the same factual circumstances. Because otherwise, aren't you just always going to be just sort of guessing, sort of, yeah, that's kind of sort of the same thing, so that's the same?
Don't think it's a guess. So first, there isn't an allegation here that those factual circumstances aren't the same, but your question is still well taken. In this case, we are looking at the Bureau of Hearings and Appeals, our administrative tribunal, looked at the allegations in the criminal complaint and the affidavit of probable cause. Those match up with the facts listed in the CY-48. All of the dates of the incidents and the charges are the same. And we don't have the perpetrator in this case saying, hey, that's not what happened. I got endangering the welfare of a child charges because I left the child in a car, not because I left the child in the house and committed. If that were the case, we match each other. There's also a consideration of the statutory definition of endangering the welfare of a child and the type of child abuse on the CY-48, which in this case.
Pardon me, just very briefly, is it your position that the burden is on the alleged abuser to show that the factual circumstances are not the same?
Once there has been that other court determination, in this case entry into ARD, yes, the burden shifts to the perpetrator to show that those facts and circumstances aren't the same, especially because it's the county children and youth or the department, depending on who does the initial child abuse investigation, that puts in the documents that support that it is the same, whether it's after a request for a hearing or in this case, a motion to dismiss the hearing on the indicated status because it can change.
Thank you.
Thank you, Justice Mundy.
I have no questions. Thank you.
Thank you, Justice Bear.
There's lots of law that recognizes that people at a MDJ level plead guilty to reduce charges as a matter of convenience, simplicity, etc. The same thing is true for ARD. You may well not have done it. Unlike a guilty plea quality, you don't have to concede you did it to get into ARD. It's a pre-trial disposition. People have argued it's in a legal sense, but that's not here before us today. So it's bothersome to me as a matter of core due process that because somebody wants to go ARD, they eliminate the expense and uncertainty and get back on in their life, do 200 hours of community service and done. That equates or that forces them to forfeit the right to contest the founded child support. And I appreciate that the legislature said that, and that's where you're working. But the legislature also said, as people have pointed out to you, in the administrative agency law, that if there's an adjudication, you get a hearing. So arguably, we have a conflict between statutes. And my question is, given the reality of ARD, and that we don't want to chill people from not going ARD because of this, why don't we find in favor of the administrative agency law and let you give them a little hearing?
Well, I think if we look at the purpose of ARD and the purpose of founded report and the state's interest in protecting children, there can be some balance found. So much like ARD has been found, the person waives their right to a child, they waive their right to the statute of limitations. They're also, at least temporarily, waiving their right to be heard by a jury of their peers. They enter that for whatever strategic reason. They receive sanctions for a limited period of time, and then their slate, based on successful completion, is wiped clean. Here, we have sought the benefit of ARD, just like one might plead guilty or no contest, rather than go through the costs and time associated with, especially some of the more minor criminal charges. they receive sanctions for a limited period of time, in this case, a founded report. And once they've successfully completed ARD, they can show that successful completion, the expunction of that record, back to the department. The department removes the founded status. It goes back to indicated. And at that time, both the statutory bar on employment would be lifted, because there isn't one for an indicated report, and they would be able to appeal. The burden would be on the county or the department to show that the abuse happened by substantial evidence.
Let me just a follow-up. Is the removal of the founded report upon successful completion of ARD ministerial? Does the department have any choice but to remove it?
I think based on the language of 6341C.1, they don't have any option to not remove it. So that section says that a founded report, if you can show that the underlying court determination is vacated, in this case, it would be an ARD would be expunged from the record. If the perpetrator can show us that court order, I don't see any room for the department to maintain the founded status, because that underlying court process is gone.
Thank you. Chief, thank you.
Thank you. Justice Dodd.
Thank you, Chief. Or it seems to me that your particular case is persuasive based on, in part, the facts that individual mother here actually admitted prior to or the ARD proceedings. She admitted the exact facts that would give rise to your founded report. In other words, she was alleged to have left her two 15-month-old babies alone in their cribs all night while she went to a bar, and that was the basis for the criminal charges and the ultimate ARD, and that's also precisely the basis for what your department did. So it seems to me your case, your facts are particularly compelling. However, my concern and our court's concern is always we write these cases for the entire Commonwealth. And I'm just not sure, echoing the concerns expressed by some of my colleagues, I'm just not sure that that answer applies when the facts are not so neatly lined up as they are here. And I wondered if you could just comment on that.
I think in cases where the facts aren't so neatly lined up, and I have certainly seen that in my own practice, then there is an opportunity to be in front of the ASA, our administrative tribunal, and have the county and the perpetrator either show that the facts are the same or the facts aren't. The difference in this case is that Commonwealth Court is requiring an adjudication of the facts rather than just the comparison between the Common Pleas Court set of facts that it was operating under and charges and the Child Protective Services Law and the CY.
All right, thanks.
Thank you. I see we're at the 2-minute mark, so if you had a word or two of summation, I'd appreciate it.
Very briefly, Justice, thank you. The legislature included ARD in the definition of founded report. If you look at the change in the definition from 2013 to prior 2013, they expanded it greatly and used very specific intentional language in each of the 4 sections and 4 reasons you can found a specific report. The nature of ARD itself does not lend itself to adjudicated facts. In fact, if you look at the Criminal Procedure Code, you'll see that the Criminal Procedure Code requires that you go off the record to discuss the facts before the judge agrees to entering into ARD. So therefore, to require adjudicated facts before you can found a report goes against the legislative intent and plain language of the CPSF. Thank you.
Thank you. Mr. Lydon.
Yes, sir. Chris Lydon on behalf of Appellee. I would just say, just in response to Justice Todd's comments, the facts, this is purely hypothetical, mind you, but I would say the facts don't line up here that mom didn't admit anything. I mean, that's the whole problem, is that it's just a claim. There's just a claim in a report that turned into a founded report later on that mom made these admissions, but we don't know that. That's not part of the record of this case right now, and it certainly didn't come up in an ARD proceeding, which is a by rule of procedure is a non-record proceeding. So I just would say, just generally speaking, if there's any ambiguity in these statutes and how they're interpreted, that it should weigh in favor of appellee, because there's a lot at stake here for people, and ARD ought to be something that's equally available to both innocent and guilty defendants. And you're going to make it very, very difficult for innocent people to avail themselves of the benefits of the ARD program when their name is going to be on this registry, which basically marks you with a scarlet letter on your chest. So that would be my argument as a matter of policy.
Thank you. Justice Donahue.
Counsel, pardon me, can we go back to a question that Justice Baer asked earlier, which is the degree of certitude that after the ARD program timeframe has expired, that the founded report indication will be removed. As I understand the statute that your opposing counsel referenced, the founded report will be removed or eradicated if the disposition is vacated, is, I believe, the language of the statute, which is different than an expungement. And so my question to you is, do you see it as a certainty that at the end of the ARD period that there will be a eradication of the founded report indication?
Well, I mean, the word vacated is troubling. It's very difficult to vacate.
It requires a court order, does it not?
Right, and that, to me, it appeared just reading it, and I admit that I didn't research that particular issue since I was purely seeking to try to get an evidentiary hearing. But to me, just logically, it doesn't match up. That I don't think it's an automatic that you're going to get this from produce a document showing that this has been expunged.
Okay, thank you.
Thank you, Justice Dougherty.
My similar is very similar to Justice Donahue's. The position or the founded report can either be vacated or reversed, but an ARD is expunged. So the question I have is, do you distinguish that particular term of art as not falling within the statute such that an ARD successful completion can still be challenged and the founded report remain if we're reading the statute as it's plainly written? That's my concern.
Yes, sir. Answer that not directly. Just by pointing out that there's still a lot at stake for the litigant, because they may be on probation doing for ARD for a long time and may be suffering consequences of that, of being on the registry. Again, when theoretically they may have been completely innocent of whatever claims came down the pike. So I still feel there's enough there to warrant a little hearing on this matter and give somebody a chance to be heard on the reasons they entered into the program.
How do you follow that logic with the plain reading of the statute that ARD equals founded report equals no hearing?
Well, I hate to say, I would disagree with you. I don't think it says equals founded report. I think there's enough. I mean, I'm not going to quote the language. We have it all in front of us here. Right. There are no facts aired out at the ARD program. There's only a decision by the court. So there's nothing that's been aired out that would warrant putting somebody on this registry.
Fair enough, but that would have been a challenge to the statute for which you did not make.
Okay. I still think that there's been no airing out for the reasons of going into the program. Now, you do have some language to work with there to the extent that there's any ambiguity in it. I would ask the court to, again, if there's an ambiguity, the court has to decide what these statutes mean. And I primarily am raising a policy point here, oral argument, that you should consider weighing in favor of the appellee and what's at stake for appellees in like circumstances.
Thank you.
Thank you, Mr. Leiden. Justice Wecht.
Thank you, Chief Justice. Good morning, counsel. With respect to the language in subsection A2 regarding same factual circumstances, what, in your view, is the minimum level of process that must be afforded to the alleged abuser before the standard is satisfied there?
Well, to compare it to a guilty plea colloquy where, you have the DA reciting the facts, they could recite the facts quickly. The court could say, Mrs. Defendant, is that true? If they say yes, then that would be sufficient. But again, ARDs are non-record proceedings, so you're not going to have that. You're not going to be able to pull a colloquy and hear that conversation. Those conversations are held off the record. And
you couldn't, just to interrupt you for a moment, and I'm thinking about the chronology. It wouldn't be feasible to build that record by bringing your own court reporter, so to speak. By CYF, for example, if it knew about the ARD, bringing a court reporter and getting some kind of record, it's not going to happen, right? Because CYF's not going to be prepared in these cases to develop that back at the time of the ARD hearing, right?
That, and there'd probably be a frictional cost there too. I don't know that the Common Pleas Court would be particularly pleased, because they might view it as somewhat disruptive. It may make it more difficult to have these proceedings go through.
Because they may have an assembly line going on, and they're not going to want to have a colloquy for CYF. Okay, thank you.
Thank you. This is Monday.
I have no questions.
Justice Bear.
Thank you, Chief. Just really briefly, because it's not the meat of the legal argument, but I wonder if you're looking at gift horse in the mouth. You win before us, you get a hearing. Your client did indeed go to a bar from midnight till 6 a.m. That is child abuse, and you're found it. Instead, she goes ARD as a matter of convenience. She waits until she does her community service and the like, and it gets vacated. Is it the smarter thing to do to not go your route and to just go ARD and get rid of this eventually?
That's a tough question, sir.
Okay, this bothered me.
I understand your point.
When the legislature, the problem here seems to me to be due process. I think that's what you're arguing, and I think that's what bothers me. Although I don't know that you raised that, and you can certainly waive constitutional issues, as you know. What the Commonwealth Court held is, under the administrative agency law, this equals an adjudication, and the adjudication can't occur without a hearing. The other section of the law that we've all talked about says if you go ARD, you don't get a hearing. What do we do with what I perceived when I went through this case as a conflict between two sections of Pennsylvania law?
Well, as I had mentioned before, I'm not an expert in statutory construction and interpreting constitutional and constitutional law, but I would say, just as a matter of policy, that I would ask the court to consider appellees that have a stronger interest here, because of the brandishing effect of being placed on this registry and how it limits your employment opportunities and just how you're viewed by people in society in general. There's a lot at stake for people.
All right, I appreciate it. Thank you very much. Thanks, Chief.
Thank you. Justice Todd.
I have no questions, Chief.
Thank you. Mr. Biden, you have a sentence or two of summation?
No, sir. I've made the comments that I want to make, and I appreciate this time.
Appreciate that. And of course, we have the benefit of not only the argument, but the brief. So with that, we'll conclude this argument and adjourn until 12:30.
We're in recess.